CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back.
You then, in relation to the defence under the presumption of innocence, you had questions then for the Garda in question. Do you want to read them out? Because coming from your voice might sound a bit better.
Yeah, and bear in mind, this is all about him being able to prove.
Yeah.
So the first question would have been, what phone was I holding?
Okay. So you want to know from the guard, could he identify the specific type of phone that you had allegedly in your possession?
And bear in mind, there's no evidence of this in the evidence that had been forthcoming.
Right, okay, grand.
The next one is, where is the phone?
Okay, so the guard didn't actively seek to take a photograph or seize the phone as potential evidence in
No.
a court case.
No. So, I mean, how do we know this phone ever existed even?
Correct, okay, I can see where you're going with that. Right, so what's the next question?
Where is the evidence to prove that I was holding it?
Okay, right, so the two are tied in together.
Yeah.
So the first question again was, what phone were you holding and where is that phone? So if he hasn't got the name or the type of the phone, first of all, and then he hasn't got the phone, he actually has no evidence that that event ever took place.
No, and bear in mind, he has to prove that it took place. So at this point, I would then address the judge and say that because he cannot prove that the call was made or received or texts through the phone records as they pertain to the phone number, not the phone. So
did he actually, no, I think you told me this before, but did he actually get a record of the telephone number?
No.
No, he didn't actually seek that either.
No, nothing. There's nothing in his evidence that he's relying upon that mentions the telephone, apart from in his contemporaneous notes where it states was on the phone.
Yeah, well, you see, again, the point I think we should make for the listeners is, when a guard approaches you and makes an allegation, that is their grounding charge for whatever else follows. So very often we find with people is that the grounding charge that they led with somehow fades away or drops away for some reason or another, because they have found something in their mind that is better to go with.
Yeah,
and
so
clearer to go with.
just to give an example of that, quite often you're stopped for something and you end up in court because you had no tax, even though you weren't stopped for that necessarily.
For that purpose.
Yeah.
So it's very important from the outset to establish what it is the guard wants.
Yeah.
Like, I mean that in a literal sense. Like, I mean, it might sound a bit cheeky, but saying to a guard, the probably a better question rather than saying, what do you want? Well, they have to tell you, irrespective of the way you put the question. But the better question is there an emergency? Now, then they have to tell you why it is they're stopping you or they're engaging with you. Because if there isn't an emergency of some form or another, they're actually not entitled to stop you.
Yeah.
Or engage with you. A guard should walk around with his head up in the air, ignoring everybody until such time as an emergency occurs. Now, an emergency could be they perceive a criminal act has taken place or is taking place, or commission of an act, a criminal act, or if there's a crash or if somebody's gotten hurt, i.e. either a criminal offence has taken place, or there's been an accident. That's the only time they can engage with you, legally speaking. It's a good thing to remember. Just say to a guard, if like it's the listener's call, like, what is the emergency, or what exactly is it? Why did you stop me specifically? And then they have to tell you what they suspect, and then they can go on and engage with you. And then if they suspect something, they have to particularly and specifically tell you the act and the code, the statute, and the specific section under which they're stopping you.
And they have to be able to quote it to you.
Quote word for word what it is, and then explain it to you if you don't understand it.
So it's we always come back to this, but it's very useful to have a record of what goes on.
Absolutely, yeah. Now, we were asked this before in the context of doing a school or a tutorial, and people were there. Like, we do invite stupid questions. We don't believe there is stupid questions, but we do invite people to ask questions. And we've been asked, and I won't say who asked, but we have been asked, well, how do you take a record if you're in your car?
Yeah.
Okay. Well, there's very simple things you can buy out there, and they're promoted for the insurance industry. And they're a car camera.
A dash cam, yeah.
A dash cam. And I think they're relatively cheap at the moment.
You can buy them in Aldi as we speak.
Yeah. So a dash cam is sufficient. You just put it on there. I think it renews itself as well. You can download, obviously, and record what's going on, but it renews itself. It's an automatic thing, so it just constantly records for a period of 24 hours and then updates itself, renews itself.
Yeah.
So you can always have an ability to record somebody that approaches you, especially if you're in the car. So there's no excuse.
There isn't really, and if you've got it recorded, that's a powerful defensive weapon or tool.
Especially if you're listening to the CLS talks.
Exactly.
Okay. What was the next thing then, Lionel?
Well, I was asking the judge then to dismiss the case with prejudice, because if there was no evidence of what, if any, phone was allegedly in my possession on that day, well, then that's the obvious thing to do.
And that's the grounding charge as well, so the whole case would have to go.
Yeah.
Okay.
Now, if that was turned down for whatever reason, I had planned on asking what reasonable grounds has the guard, this is the cross-examination continuing, for believing that a fixed charge offence was committed. Okay,
that's I'm not clear about that, so can you... What reasonable grounds have you for believing that a fixed charge offence was committed? I don't... Well, I know there's something in it.
Yeah, what I'm trying to get him to do there...
I'd be confused with that question if I was the guard.
That's the idea. I'm trying to get him to state a belief rather than a proof. So what reasonable grounds have you for believing that a fixed charge offence was committed? In other words, why were you stopping me? What did you believe was going on? Comes back again to what you were saying a couple of minutes ago. So give me your grounding, give me your basis, because then I can come back at you and ask at what point did you state the law, state what I had...
led you off in another direction with them.
Yeah,
okay.
Exactly.
So you were in the position then, potentially, of further in more detail cross-examining him about the events on the day.
Yeah.
In a lot more detail, obviously.
Plus, I wanted to get him to state a belief, because a belief is not proof of anything.
Okay,
so that would further confuse the issue and muddy the waters for him on the stand.
It's a very... looking at it without having the context, it's a very confusing question, and you have to... I'd imagine, which you told me before, you put yourself in the position of the guard.
Yeah.
So you're purposely trying to confuse the guard?
I wouldn't dare do that, obviously, but yes, quite clearly I am.
Well, you know the context, but the problem is, of course, for the guard, he doesn't know the context. He doesn't know where the question is going.
Yeah.
And this is something the listeners need to tune into. Nobody knows what's in your head, especially if you're doing a cross-examination. The guard, or whomever is in front of you that's being cross-examined, they don't know which way this is going to go. So whatever perceived pressure you feel from the court, somebody standing in the witness box, especially if you're on top of your case, they are going to be, excuse the phrase, shitting a brick. And you'll see it in them.
And I think at this stage as well, because of course I've laid out grounds for defence there, and if I'm this far in the case, it's probably quite obvious to the guard that I'm not letting go of this. I'm like a dog with a bone if it's got this far. So it wouldn't be a particularly comfortable situation for him to be in at this point, I don't think.
Well, this is part and parcel too of the psychology. We refer to the art war, we won't get into it again just now, but there's a huge psychology involved in this. And if you put... We'll say the first set of questions that you had put to the guard, obviously, you know, the outcome was defined upon that set of questions. But if this had rolled on into the next set of defences, the next defence, and these types of questions started to come up for the guard would soon realise he has his work cut out for him. He really does, because he has somebody now in front of him that is well capable of asking them very, very difficult questions.
Yeah.
And would allude, and potentially could allude, to him not acting properly, as in dereliction of his duties as a guard. So these are potential time bombs for a guard to be asked. And from my impression of what we've read so far, the guard was lucky that you didn't end up getting into a situation like this, because you would be challenging his validity, his duty, his ability to be a guard. Because I can't imagine he'd be able to address these sufficiently well to come back at you with anything.
Well, I don't think so. And having experienced how he handled or failed to handle cross-examination as it was, I'm pretty sure he wouldn't. And it does get a little bit hairier for him when we go on a bit further into this, potentially hairier.
Okay, what's the next question?
The next question was, isn't it true that you hold the burden of proof to successfully convict me of these alleged offences? Now, he can't say no to that. If he says no, well, then we have grounds to have it dismissed. And if he says yes, well, then we carry on. So I suppose that's what you call a leading question. Because the next question is, isn't it true that you have no evidence allowing you to prove beyond all reasonable doubt that I am guilty of these alleged offences? So everything that I've asked him up to now is leading to this point. Now, we already have the evidence, so we know that the answer to that question is that he has no evidence. If he says yes, I can wave the evidence in the face of the court and say, well, hang on a minute, he's just told a lie and he's committed perjury. What are we going to do about that? If he says no, well, then my closing argument is, and I'll address the judge, with the burden of proof patently on the prosecution and in cognizance of Wilmington versus DPP in 1935 and DPP versus Department of Transport 2003, wherein Justice Hardiman did state that, as you've said earlier on, we won't go into it again, allied with Article 6.2 of the European Convention of Human Rights, which states that, again, we've discussed that, see above, and in the absence of said proofs, we must be presumed to be innocent of these charges and consequently now move to dismiss with prejudice. There really is nowhere for anyone to go at that point, well, in my humble opinion.
Like, I know that I'd be fairly aware that in putting this page together, we'll call it, of this set of questions, that would have taken a long, long time.
Well, bear in mind, at this point in the case, we're well over 2 years into it from the time of the alleged offence, and there had been a series of back and forth, and I think this was the third appearance in court on it. And there's a huge amount of work. It's condensed or codified into one page for me, so that I can quite literally, when I'm in court, read the questions, because I don't want to make a mistake. And I know that the chances are I will make a mistake or forget something or get a bit flustered if I don't have it written in black and white before me.
Okay, so that's basically the burden of proof in relation to them being able to prove beyond all reasonable doubt that you committed a crime. They didn't have it, they couldn't have it. There was no proof of intent, there was no proof of an act of a crime. So the case should never have gone to court. No, it shouldn't have. But it did, and just in case other stuff happened that we didn't want and defence 1 and 2 had been thrown out, I prepared a third. Defence 3, legal and lawful undertaking to discharge matter and related unreliability as a witness. Wow, it's a heady old title again. Okay. Yeah, and this is kind of where we get into, as you talked about there a few minutes ago, whether this guy should even be a witness. Should he be a guard? Is he capable of doing what he's trying to do or attempting to do at this point? Because that is very, very important. If this guy isn't fit for duty or isn't fit to be doing what he's doing, why are we here? So what's going on? So again, going down the route of cross-examination, the first question for the guard, isn't it true that you have sworn the following oath? Quote, I hereby solemnly and sincerely declare before God that I will faithfully discharge the duties of a member of the Garda Síochána with fairness, integrity, regard for human rights, diligence and impartiality, upholding the Constitution and the law, and according equal respect to all people. Okay, that's a fair mouthful for them to declare. Now if he says no, okay, right, well, you're not a guard, let's end this now. Yeah, he shouldn't be there at all, so I mean, you'd have to assume he says yes. Exactly. And for those wondering, well, why are you asking these questions when you know what the answer is going to be? It's a leading question. It's to get me to a place whereby ultimately the person that I'm cross-examining is backed into a corner. The point I think we need to make, it, even we probably should have made it earlier, but we're making it now, is that when they send you their evidence, just keep this in mind. Any questions that you have for the guards, or the witness that you're cross-examining, keep them relevant. Now, at this juncture, as if I was standing as the judge, I might say, well, Mr. Coveney, what relevance has the guards sworn oath got to do with? He has taken the oath. He's in the stand. What relevance has that got to do with this? Now, that might be a play to put you off.
Mm-hmm.
So how could you say to me, well, how is this relevant, Mr. Coveney, to today's proceedings? Because all I perceive from this is that it's designed to trick the guards.
Well, as you will see, Judge, when I continue with my cross-examination, I'll be bringing up human rights issues, the issue of diligence and impartiality. The Constitution will come into it as well, and of course the law, and the oath directly states that these are all a part of the duties of a guard.
Okay, well, I probably, if I was prepared, further challenge you on that, but we'll continue on anyway.
Mm-hmm. Isn't it true that I wrote to you on 10th of February demanding information and answers, which you failed, refused, neglected to provide? And just to give a bit of context there, I had written to the guard well in advance of the Gary Doyle order being sought several times, looking to see, look, guard, what's going on here? I need some information, so I need some answers. Can you get back to me?
Okay.
You know, give me some kind of context for why you're trying to bring me into court.
Okay. Now, when... Just for the listeners, not so much for yourself, Lionel, when you ask a question like that, there may be a contention of, well, are you making legal submissions, or are you providing a submission to the court in relation to this? So if you ask a question like that, the judge may say, well, what are you talking about? Are you providing legal submissions? Have that paperwork ready to hand as part of a submission necessarily to the court if required.
Absolutely. Yeah. And just on that point as well, not that they'll necessarily have it, the court was also sent all of these documentations, CC'd on everything that ever went to the guards. Yeah. So, and again, I would have a record of that.
Grand. So just to keep that in mind, listeners, is that when you're talking about retrospective letters, whatever you do, notice demands, whatever it is you sent to them, bring those documents with you. So there is no excuse, because the corollary, or the opposite to that, applies to you as well. When you're seeking that they provide the law, they have to have the law. They can't just say, well, we're relying on such and such a law, but not have it in court.
Yeah.
So you need to have your submissions available, irrespective of who you sent them to in the past. Okay?
Yep. So the next question, isn't it true, therefore, that through your refusal to provide information to me until directed to do so by the judge in question, you have demonstrated a clear breach of your oath with regard to according equal respect to all people?
Okay. So again, what are you asking them there? Because it's a long question.
Yeah, essentially what I'm asking is, well, haven't you treated me with a complete lack of respect? By ignoring me, you have raised an issue with me. You're trying to find me, or whatever it is you're trying to do, and I'm trying to discuss this with you now, and you're point blank ignoring me.
So you're acting contrary to your oath.
Exactly.
Okay, that's the question. So how was he supposed to answer that? He'd have to say no.
He'd have to say no.
Yeah, he couldn't say, yes, I am not treating you with equal respect.
Yeah.
Okay.
And again, I have these written down, and if he says no, I'll make a little note of that, because I can potentially come back to it then as well.
So a lot of these are just yes, no answers, really, you're seeking. Okay.
And that's what I'm looking for, yes, no answers. Isn't it true that further to my notice demand for information and answers of 10th of February, you gave tacit consent to the discharge of the matter? So what I'm talking about there is, I asked a question in that aforementioned notice demand of 10th of February when I said that, look, in the absence of a reply, it will be deemed to have been discharged.
And in the absence of you providing proof, essentially as well, notwithstanding the reply, you can seek to have the case dismissed or struck.
Yeah.
Okay.
So if he said yes to that, I'd move to dismiss based on the unreliability of the witness.
Right, yes.
And if he said no, well, then I'd demand proof of rebuttal. And in the absence of same, and we know there is an absence of same, move to dismiss based on the unreliability of the witness.
Okay. On the face of this, that question, it's a good question. The issue, perhaps, the court might actually have issue with that, because they might suggest, well, you're flying in the face of the court by saying such a thing because you're trying to make a determination outside of the legal process, which you're actually allowed to do.
Well, you are allowed to do, because when you receive your fixed charge notice, They're making you an offer.
Yeah.
And of course you can make a counter offer.
You see, if your argument here is, well, to be honest with you, we shouldn't be in the court anyway, because this is a non-issue. It should never have gone to this position, in terms of the court don't have any jurisdiction to proceed with such a case because it's rubbish, basically, or null and void. Your argument there, and the aftermath and the laterally, could be, well, the court facilitated the abusive process by the Garda Síochána, because the court should know what should or should not be laid before the court.
Yeah.
At the face of it. And if you attempted to address this matter ever prior to going to court, the judge, that should have been a question of jurisdiction that was raised with the court. Mm-hmm. Now, at this stage, it would have been raised, but obviously the judges don't like this issue of you trying to settle matters pre a court, because it means they get nothing out of it. But you still have the right to do that anyway. So I don't know if I've made the point there clear.
No, I think that's very clear.
That's a jurisdiction issue. Yeah. So what you're actually doing there by that question is indirectly challenging the jurisdiction of the court to preside in such a matter.
Which opens up a whole new can of worms. Which,
in my opinion, now again, we're looking at this retrospectively. Yeah. In my opinion, the jurisdiction issue should have been raised
at the outset.
At the outset.
Yeah.
And it may not have gotten this far, where if you inform the court that they haven't got jurisdiction on the basis that you attempted to settle this matter. Now, this is only a potential another way to look at it for people. If you attempt, and under your rules of writing to them, you said, well, we're affording you the opportunity of proving such and such a thing, and such a thing was done correctly and lawfully, and so on and so forth. And in the absence of you providing said proof, you don't have the jurisdiction to proceed with this. That's essentially what you were saying indirectly to the guard, or directly to the guard. So the issue of jurisdiction potentially could have been raised at the outset on that basis alone.
And one of the beauties of a jurisdictional defence like that, which I wouldn't have known at the time, is it can actually keep you out of court. And you may never have to appear in court, which ultimately is what we're all looking for, isn't it? I mean, it's not a nice thing to have to prepare these defences and go in and out of court. And aside from the psychological terror that it wreaks on most people, it's a massive headache. It's a huge amount of work. So if that can be avoided at all, that's obviously the goal, I think, for most people.
I think we've addressed jurisdiction probably on many, many occasions. And it's something that goes past people for some reason. Well, in the strictest sense, if you fully grasp what jurisdiction is about, you can avoid court, providing of course you haven't broken the law. We take for granted that you're not actively out there trying to break the law, that you can avoid ever going to court if you haven't broken the law, because they can't establish jurisdiction. Now, it's not as easy as we're suggesting, but in the strictest sense, if the law and the court were law abiding, we'll say, then you would not have, there'd be an awful lot of cases that just would not ever see the light of day.
I think if the court was law-abiding, there wouldn't be a legal system, because the whole thing had collapsed. There'd be no money coming in.
That's the problem. That's the problem for the court, of course.
Yeah.
Right, so just on that, folks, now we'll there's a caveat to everything, but if you haven't committed a crime, the only way they gain jurisdiction over you to go to court is by you consenting or conceding jurisdiction in some way or another.
Yeah.
So jurisdiction, irrespective of whether or not you go to the court, jurisdiction should be the prima facie objective of what you want to deal with whenever you attend a court. Jurisdiction is the key. If they cannot establish jurisdiction, there'll be no court case.
And that can apply to pretty much anything. You may have committed the most heinous act that you could possibly imagine, but they can't successfully prosecute you without establishing jurisdiction. The act itself that you have allegedly committed will never even be discussed, provided jurisdiction is the issue.
So again, like, we're looking at this, listeners, retrospectively, and Lionel didn't know everything he knows now, and back then he knew a lot. So it's just a matter of he's learned a bit more, and same with me, myself. I've learned a bit more as time has gone on, and then a little bit more and a little bit more, and how things eventually sort of click into place for you. They don't happen overnight. It does take quite a while. It's like, I don't know how you'd align it, but it might be like studying for a master's maybe, or a doctorate or something like that. Eventually things click into place.
Yeah.
And that can be, it is a combination of personal experiences and study. It was for me anyway.
Likewise, yeah.
They don't talk to
CLS Talk.